Once upon a time, cigarette advertising was everywhere in Australia, from sports to women's magazines to train stations. In the 1980s, governments started banning tobacco advertising. The New South Wales State Rail Authority had leased space on its railway platforms to an advertising firm, Heath Outdoor, who built advertising hoardings there. In many cases, the ads were booked for long periods and often by cigarette companies. When the government prohibited cigarette advertising on government premises, these contracts were thrown into disarray. The contract between State Rail and Heath Outdoor included the following clause. The authority may terminate this contract at any time upon giving the advertiser 1 calendar month's notice in writing of its intention to do so. This was apparently a standard clause included in every state rail contract. Evidence suggested that this clause had always worried Heath Outdoor. They made a substantial investment up front, so they needed to have advertisers contracted for a long period to make back that investment. Prior to contract formation, they had raised this concern and received an assurance from the Rail Authority that the clause was just standard boilerplate. When the cigarette advertising rules changed, the Rail Authority essentially gave Heath Outdoors a choice. Remove the cigarette advertisers, or we will use Clause 6 to terminate the contract. Heath Outdoor argued that they couldn't do so because of the oral promise that they were safe for the duration of the contract. The court had to work out whether the Parol evidence rule prevented any evidence being given of the oral discussions. The court found that the rule does not prevent evidence being given where the contract is partly oral and partly written. Justice McHugh said that the Parol evidence rule is a rule whose scope and rationale is often misunderstood. It has no operation until it is first determined that the terms of the agreement are wholly contained in writing. The tendering of oral evidence to prove a contractual term, therefore, cannot be excluded until it is determined that any terms in writing record the whole of the parties' agreement. In this case, however, the court found that even with the evidence of the prior conversation, Clause 6 was still valid, so State Rail was allowed to terminate the contract. From this case, we learn that the Parol evidence rule has no effect where a contract is partly oral and partly written.